Welcome everyone to this Privacy Rules, Privacy Espresso. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules. And I'm today with Stephen Mathias, expert from India, from the law firm Kochhar and Co, to discuss about the latest news coming from India, that is the new bill related to privacy that has been recently published. But first and foremost, Stephen, thank you very much for being with us today. My first question for you is exactly, can you provide us some background on the history and the reason why we have this bill today?
So India actually prepared a draft data privacy law way back in 2018. It's now 4 years. And there was a revised draft in 2019. And then there was one more that was released December of last year. That was a fairly detailed draft law, which is styled on GDPR. And my general feeling was it was a bit of an overkill. And it was, too much regulation for a country like India, which has a fairly large, unorganized sector, as well as, small and medium enterprises who would struggle to meet GDPR level compliance. I think the government realized that sometime during this year, and they pulled back the draft and said they'll come up with a new draft. So this is the new draft that was released a short while back.
Perfect, Stephen. Thanks a lot for this brief overview on the history. Speaking about the law itself, what was the approach used? Is it, for example, similar to GDPR model as many other countries have been doing so far, or is it different?
Actually, it's quite a surprise because it's a much simpler draft than the previous ones, and it differs substantially from the GDPR model. It's a simple draft with just a few prescriptions. Gone are many of the provisions that were there in the previous drafts, like data portability, privacy by design, and data localization and so on. So a lot of that is missing in this draft. It's actually an approach which I had recommended all along, which is have a light touch approach and enable the Data Protection Authority to build the law slowly through regulation. After all, if you look at various areas of law, like say banking, securities law, telecom law, most of the law comes through delegated legislation, through regulation, rather than through the statute. And I think that's actually required, not just for India, but for most countries. So it's kind of like a third way. We had the initial data privacy legislations, which are very consent-based. Then you have GDPR, which many countries are following today. And this is kind of a new path which the government has set out. The key issue really that everyone wants to know about is what's the ground for processing personal data. Here, the ground is mostly consent. There is no clear, legitimate interest type of provision, which is, I think, the heart of data privacy regulation today. There are two sets of grounds which are covered under deemed consent. One set where it's in public interest. So, things like network security and creditworthiness and so on would fall under that. And then there's another set of grounds which deal with where the processing of the personal data is considered to be necessary. So in that, you have one ground where the personal data is given voluntarily and it's necessary for processing. And there's a reasonable expectation that the personal data would be asked for. And in that situation, you can continue to process. So this is somewhat like legitimate interest, but I'm not sure it really is. There are a few other grounds like, for instance, contractual necessity or compliance with law and so on. So we have to see how this plays out, but it's not absolutely clear that you will be able to process personal data without obtaining consent.
That's very interesting, and it's a big difference from other regulations. So thanks a lot for sharing. How much space there is of interpretation in these?
Well, I'll say the drafting is not very tight, and there is scope for a lot of improvement. I think when you have a simplistic draft, And that too, when you have a law which is not modeled on any other law, then you will find lots of gaps and lots of drafting, issues. So the government has asked for feedback by December 17th, and I guess they will come up with a revised draft, which will probably be the final draft that will be presented to Parliament. And so maybe many of these things will be addressed. But I think that it's with most laws, but particularly in data privacy, interpretation is an important aspect, and you really need to allow the law to grow along with the world of data privacy as well. And so I guess that would happen as we go along.
Perfect. Thanks a lot for this answer. And there is another point that I think may be of interest, that is the one related to data localization requirement. It appears to me that there is no such a requirement there, but is that true?
Well, there's a difference between data localization and data transfers, that is cross-border transfers. So data localization in terms of the law stating that this data or that data must be stored only in India, or a copy must be stored in India, those provisions are missing. And there's no hint that it could come in through delegated legislation either. But there are provisions on data transfer out of India, where it says the government will notify to which countries you can transfer personal data out of India. Again, a rather simplistic clause in the sense that it doesn't address other forms of cross-border transfers, such as intergroup transfers, or most importantly, standard contractual clauses. So that's probably a clause that needs to be rewritten, because there will be countries that you might want to send data, but those countries are not, got the stamp approval from India. And as is the case when you look at data flow the other way, that is from the EU to India. So in that case, SECs are mostly used for data to be transferred to India. So India should do the same as well.
Clear. Perfect. Thanks a lot. Thanks a lot, Stephen. Just a quick question, because we still have a bit of time. Would be how does it work for penalties?
So there are penalties. It's a matter of interpretation whether you call them big penalties or not. They're clearly not as troublesome, as worrying as it was in the previous drafts, which talked about percentage of global revenue and so on. So they have a schedule where they have mentioned penalty amounts that can be awarded for specific violations. I do feel that some justification needs to be provided within the statute itself. That it penalty should be proportionate to the harm caused and so on. Some of that language is already there. One very important aspect is compensation to data subjects is missing. So it's only penalties. There's no compensation prescribed in the law.
Okay, that's a very interesting point again. So thanks for raising it. Just to conclude, one last question is, what do you foresee for this draft?
So the indication I've got from the government is that there is some frustration over the fact that this law, the draft law, came out in 2018, and now we are at the end of 2022, and we still don't have a law in place. The government is also on a kind of a three-law mission. So one is to replace the telecom law, which a draft has already been released. Then there's this one, and to also release to bring in a new law to replace the Information Technology Act. So that will come next. And so I think there's a very clear agenda that these laws need to be passed quickly. So I expect the budget session next year, which begins in February, this law will get passed. So I expect that by end of April, it should be passed unless something goes drastically wrong. I had this one last thing I wanted to say, which is in preparation. There are really two stages of preparation. One is knowledge gathering, where you're understanding what the law is and what it's required to do. And the second is where you actually start to make changes to how you deal with data to comply with the law. So we are recommending the first one at this stage, because we expect there will be changes to the draft before it's presented to Parliament. So that's it from me, and great chatting with you, Alessandro.
Thanks a lot, Stephen, for providing us these very quick but extremely useful updates today. I would also like to thank all our listeners for being with us today. If you need any kind of support related to this new bill, feel free to contact Stephen Steve and Mathias from Kochhar, and looking forward to meeting you all in our next Privacy Espresso next week. Thanks a lot again, Stephen, and thank everybody. Bye, everyone.